Ms. Low Yen Ling.
Mr. Speaker, the Consumer Protection Fair Trading Act, or CPFTA in short, protects the consumers against unfair practices that all suppliers, including home-based businesses and micro-businesses, might have engaged in. Misrepresentation of goods and services constitute an unfair practice under the CPFTA. Consumers may approach CASE, the Consumers Association of Singapore, for assistance in seeking redress from suppliers. CASE can represent a consumer to negotiate a settlement with an errant supplier or mediate between a consumer and an errant supplier. If negotiation or mediation fails, consumers may file a claim with the Small Claims Tribunal or seek other forms of legal redress. In egregious cases, CASE will refer errant suppliers to CCCS, which is the Competition and Consumer Commission of Singapore, for investigation under the CPFTA. CCCS may then apply for a court injunction to restrain the supplier from engaging in the unfair practice. The courts may also make accompanying orders which include requiring the supplier to notify consumers of the injunction order and to report to CCCS any change to its business, such as a change in address.
Ms. Yeo.
Thank you, MOS, for the reply. We have seen in my constituency the blossoming of home-based businesses, especially during and after COVID-19. And in response, I have seen more residents support such home-based business, sometimes even operated by their neighbours. While the vast majority of the home-based business transactions have yielded very happy results, residents have given feedback that more balance need to be given to help represent the consumer rights of residents should the deal go south. As I understand it, if the home-based business is not registered with ACRA, the only way forward is through the Small Claims Tribunal, and is an online self-help platform costing up to $25.50 for a court application. For many of the consumers, the cost could be an issue, and some would appreciate assistance with the mediation process, especially if it involves a neighbour. Given the above, would the Ministry also consider having organisations like CASE play a bigger role in safeguarding the interests of customers of home-based business, especially if they are not registered businesses?
Mr. Speaker, I want to thank the member, Ms. Low Yen Ling, for her supplementary questions. I'm very heartened to hear that in her constituency, her residents are supporting each other's home-based business. Now, I want to clarify that home-based and micro-businesses are subject to regulations like any other businesses. And these businesses need to be registered with ACRA. That's an important clarification. And the consumers, and in the unfortunate event that the transaction goes south, like what she described, consumers may approach Consumers Association of Singapore CASE for assistance to seek redress from the errant home-based businesses. Let me give her a quick example. For example, if the buyer, the consumer, sense that the supplier, the home-based business, is engaging in unfair practices, misrepresentation, they can approach CASE, and CASE will then take in the details of the transaction and provide advice or help to negotiate on behalf of the resident, her resident, or mediate and determine if it should be escalated to CCCS, the Competition and Consumer Association of Singapore. And I want to assure Ms. Low Yen Ling that CCCS, which is an agency under Ministry of Trade and Industry, can and has the power to investigate egregious home-based suppliers under the CPFTA, Consumers Protection Fair Trading Act.
Ms. Carrie Tan.
Thank you, Speaker. I would like to check with the MOS. Does CASE work with the police force in cases where, if they have multiple complaints from various consumers against the same operator or business provider? To what extent does CASE assess that this could be more than a misrepresentation but bordering on fraud for the cases to be referred to the police force for investigation? Like, is there a certain threshold, like the total number of consumer complaints against a particular service provider before it gets escalated to become a criminal fraud case?
Mr. Speaker, I want to thank the member, Ms. Carrie Tan, for her supplementary question. And in fact, CASE works closely, not just with CCCS, but also with SPF. And together, CCCS and CASE do monitor, for example, sector by sector, and including by company, whether are they receiving feedback for certain misrepresentation, and we will follow up accordingly. First case, to represent them to negotiate or mediate, and then, if need be, escalate to CCCS for further investigation. Now, maybe let me share with Ms. Carrie Tan. As far as CCCS is concerned, for example, we can even follow up with a VCA, which is a voluntary compliance agreement. If we feel that there are reasonable grounds to believe that the supplier has engaged, the business has engaged in an unfair practice, we will get the company to enter into what we call the VCA, Voluntary Compliance Agreement. And this is serious because this includes an undertaking that the business would not engage in unfair practice and would also require the business to compensate any consumer which has suffered loss or damage as a result of the unfair practice. And in fact, we will require them to indicate that, in the invoice that they issue to their customer. Now, let me also share with her, as we investigate each case, even as we take a case-by-case basis, there are a few considerations. She asked about it. For example, number one, the strength of evidence obtained in the investigation, whether are there sufficient evidence for CCCS to prove that based on a balance of probability that the business has engaged in unfair practice. Another example, another consideration is the extent of consumer harm that's caused by this business alleged unfair practice. And the third one is the egregiousness of the business conduct, etc., and public interest concerns. So all these are taken into consideration comprehensively and also seriously.